Okay, Shannon, you can put us on.
Okay.
All right, looks like we've got an audio connection with everyone. Ms. Terranova is here for the
Defendant, Your Honor.
defendant. The defendant is present with her, and Ms. Rogers, the plaintiff, is present as well.
Yep.
So there've been multiple adjournments in this case. I did notice at one point there was a motion to appoint a GAL. Did that ever happen?
No, Your Honor, that was not granted.
Was it denied? Because I almost always appoint an LGAL when I'm given the chance.
Your Honor, when, if I may, Rogers now, sorry. She was at the time represented by Mr. Gary Schutte. And then we did on a motion, Thursday morning motion day, Mr. Schutte and I did meet with you in chambers. And it was my understanding that one was not appointed because the allegations didn't rise to the level of needing the guardian ad litem, Your Honor.
All right. Go ahead, Ms. Rogers.
None of that was spoken with me. That's also why I no longer have an attorney. They went behind closed doors and they came out and I knew nothing that happened. I just knew that Terranova had to go to another meeting or something. So I was never even told by Gary that that was never even happening. So like I said, it was a lot of miscommunication on that part and that did not go very well. I couldn't even speak to my ex-husband. I couldn't speak to Terranova. It was just her and Gary went into a private room and discussed it and decided, and that was it. But I made no, I don't know. I was left in the dark with that. That was, to me, that I was never told that that was never happening. But things have changed too, as well, and with my ex-husband and I.
Your Honor, and that is, oh, I'm sorry, I didn't mean to overspeak, but I don't really know what Ms. Rogers is currently looking for today, because there has been a long period of time that has happened since we have been on the child issues. So I don't even know I don't know if she's still trying to even seek changing in custody.
Well, let's ask her.
Well, I would like it so when my kids are not with my, if they're not with my ex-husband, that they are with me. There's been we have a daughter who's 10 that's suffering in school, and my ex-husband can attest to that. Her grades are failing, and with COVID and everything else with them coming back, she wouldn't have passed. And it's a big concern to me. We are very scheduled in my home. I've never asked for anything more, anything less. I've been willing to take them. He's denied me the past 2 summers before this one, but since March or whenever he didn't have a sitter, I've had them every day but Wednesday and every other Sunday. So a lot's changed. I don't know if he had a change of heart, but I've had my kids, and we have a schedule down. We have 2 kids that are on medication. My son and my daughter are both on Focalin, and they need constant structure. And when they were at his mom's house, there wasn't the structure. They were just on their iPads doing whatever. So I just asked him if I could have them. He had no problem. But this was the first time in 2 years he's not had a problem with me taking these kids. But what we're here for today, the tax stuff, this has been for 2 years almost. February will be 2 years. I can no longer afford a lawyer. I can't afford any of this. So I'm just at my wit's end, like I said, I'm fine with the schedule, but I would just like the kids, instead of his mom taking care of them, she has a full-time job, that I could just take care of the kids until he gets out like we've been doing since March.
Your Honor, and I think in response to that, as far as when she says the taxes, I think she means the child support objection possibly. I don't know
Whatever
if-
we're at court for. Because
Okay.
we've been here to show taxes, our tax returns since February of like 18, when I had Phil Navarre.
And if I can address that, Your Honor,
Yeah.
the recommendation was for my client to pay $189 per month when he currently was ordered to pay $1,000, and he continued to pay $1,000 even though he didn't have to, Your Honor. So she's not short anything. She's actually, I'm still talking. As far as my client has been paying above what is recommended by friend of the court. So as far as monetarily, it's my client who is the one that from this not occurring has the one that's been suffering financially, because I haven't run a guideline yet. I've run 12 different guidelines and it doesn't come close to him owing $1,000 a month. So I do agree, we need to get that part wrapped up, Your Honor. And at one point there was discussion between Mr. Schutte and I that we were hopeful the parties were going to be able to work out both issues on their own, and they didn't. So I do know that we are here on child support objections from Ms. Van Dam. Ms. Rogers. That is originally what we're here for, our objections on child support. But this in no way has negatively affected her, Your Honor.
Okay, Your Honor, I would also like to add, I cover the healthcare, the dental, and the vision. I take my kids to every single doctor's appointment, dental appointment. Bills are all in my name. He has never had to ever pay anything up front. So for her to say that I don't do anything and I don't have them, I have had these kids. If you look in the original agreement, the agreement was that I would have these kids while he is not at work, or while he's at work. And I've always done that. I've adjusted my job 3 times. I've lost a lot of money because I serve and I work from home part-time, or I work full-time from home and I work part-time in a restaurant. And I have adjusted my schedule. I worked at 3 different restaurants to make sure that I can accommodate my children. I sacrificed my degree. I lost my career to raise these kids. And for him to say that $1,000 when I have them and I'm supplying them breakfast, lunch, and dinner on his days, and he picks them up at 7 o'clock at night, that's a lot of money for 3 kids. $1,000 to cover 3 kids for breakfast, lunch, and dinner, and I cover all their health care and their dental and their vision. That's what I cover. So I don't understand why Terra Nova's trying to say I'm out money. I never started all this. He's the one that took me into lower child support.
All right, I think what I heard her say is he's been voluntarily paying $1,000 a month and
That was in the
to
original
continue-
agreement to our divorce.
And plans to continue doing that?
Yep, and he also, before it was.
Hold on, hold on.
Oh.
That was a question to Ms. Terranova,
Sorry.
sorry.
Okay.
No, Your Honor, he does not continue to pay $1,000 per month. He's been doing it because that was.
He's doing that because that's what's ordered.
Correct. And they were outside of friend of the court. They opted out of friend of the court originally, Your Honor. So he was always paying her directly. And then Ms. Rogers came to court and said, I want to go through friend of the court. And Mr. Bailey, my associate, one of the associate attorneys, Matt Bailey, was here. And so we said, okay, well, let's do a child support review then too, because it had been a substantial amount of time. So it got referred back to friend of the court. And then when it got referred, the recommendation was that my client pay $189 per month. My
And there was
client
an
had
objection.
continued to pay the $1,000, Your Honor, and that was supposed to be retroactive till February of, I think, 18. My client knows he can't get that money back because it's already been paid. So that was my point, Your Honor, is that whether friend of the court's wrong, I mean, the difference between $189 and $1,000 is substantial, Your Honor. And so what my point is that he has been paying way above and beyond what the guidelines say he should be paying. That's the point, Your Honor. And
I was just trying to clarify, because all it said was evidentiary hearing on the docket, and it's been so long since this first got scheduled, I couldn't tell what the evidentiary hearing was about.
It was to show his taxes is what it was, I was told, for Schutte, or no, this was from Navarre. didn't bring in. So then it got moved again and it didn't get shown again. This has been ongoing for almost 2 years to show his financial, because he tried to say, what'd you say, like $60,000 you made? Is that what it was, Terranova, for when you had to show your proof of income tax that you never provided?
It's actually, you can call me Erica or you can call me Ms. Terranova.
What did I call you? I'm sorry.
Call me Terranova.
I'm sorry. I don't know what to call you. Sorry, Miss
That's all right.
Terranova.
That's all right. The friend of the court calculated my client's income, Your Honor, at $5,775 per month.
So somewhere in the neighborhood of 60-some thousand dollars a year annual income?
For running a car dealership?
Correct, Your Honor. And in his 2018 W-2, he made $66,333, Your Honor. And so they have a friend of the court has him at 69,300, if I calculated it correctly. He did earn a little bit more in 2019, Your Honor. And then now we have 2020, which I think we can all agree is a complete disaster on everybody's income due to COVID. So I certainly don't have his, we don't have his W-2 because it's 2020 is not done. So even if we're averaging the past 2 years, we're in the high 60s, Your Honor. So it's not that far off from what friend of the court calculated.
And I'm at 35 and then 42 for the last 2 years.
35,040.
My last year's income tax is $35,588.
I'm looking at these various calculations. I don't know.
But Your Honor, here's what's holding me back.
Go ahead.
Is we cover the healthcare, the vision and the dental. And I was paying, what was I paying? Like $600 and something a month for healthcare. Then I was paying $118 for dental. And I was still having to make the other ones. And I had to pay $100 for each, exam when they go in. And my daughter's got glasses, the other two are okay.
So you're telling me what you pay for?
That's what I was paying for healthcare for the past, 3-4 years.
Your
For
Honor.
medical,
Yes,
dental
yeah.
coverage.
When did you stop?
Okay. Go ahead, Ms. Terranova.
Thank you, Your Honor. My client actually covered health insurance for quite some time, and then Ms. Rogers indicated that she could. And so I don't know, though, how it's covered. I don't know if that's through her husband. I don't know if it's a private pay. I would assume that she would turn that into friend of the court.
I have 2 insurances.
Hold on. The support calculations take into account the cost of medical coverage in calculating what the support should be. So if you are paying those expenses and they're documented, you should get credit for those in calculating what your income is. It's baked right into the formula. You're saying they didn't include that?
In the formula? No, because in the beginning, he had the health care, and I stayed on it, I think, until the divorce was final. And then all of a sudden, I took the kids to the doctors. I don't remember when exactly it was, in like 2017, and there was no health care. They didn't have it.
For how long have you been carrying
the health
insurance?
I think since like 2000, it was like January 2017, I believe, because I had to go through a private one. It was whatever was offered through a friend of mine that sold insurance, that sold healthcare.
Okay. And you also picked up dental coverage?
Mm-hmm. Tri-dental or Tri-County.
And did you pick up vision as well?
I had to, yep.
All right, so I'm trying to figure out which calculation started this process. I'm looking at one. Hold on a minute. Ms. Terranova, if you can help me, my
can.
guess is the judgment of divorce probably said refer to friend of the court to calculate child support?
No, Your Honor, actually, the parties, Ms. Rogers was represented by Eric White at the time, and there was an agreement regarding child support
Okay,
at that time. And so the judgment of divorce didn't refer, or I think it might have, but they never went back. I can't remember, but they just continued where my client paid the $1,000. Where we got to is we only have one friend of the court recommendation that is current, Your Honor, and that stemmed from when Ms. Rogers wanted to go through friend of the court. And so when it was referred back to friend of the court, since it had been quite some time, the referral from this court was send it back to friend of the court for review. And then since she wanted to opt back into front of the court, which that is her choice, and you can do, we don't disagree with that. That's what led to this modified order, recommended order, that has the effective date of February 8th, 2019.
okay, I'm looking at that now.
Correct. And when I see that it doesn't have her monthly health insurance premiums in there, but I don't know why she didn't provide those to friend of the court. Maybe she, I can't answer that, but those aren't included. I agree that the guidelines say that if she has an out-of-pocket health insurance expense for premiums, that those will get applied. I'm not disagreeing with that. However, we're still substantially below the $1,000.
Well, not only does it not give her credit for the premium, it gives Mr. Van Dam credit for the premium, and apparently he's not paying a premium.
Correct. I'm not disagreeing with that, Your Honor. Other than I don't know what was supplied to friend of the court or what currently is going on with the health insurance. I didn't know if it was covered through her husband.
I have two. I have it through my husband and myself.
Yeah, whether it's
Because I
covered
have to
through her
have-
husband
He's
or
got,
not, shouldn't she get credit for that for covering the children?
She gets credit as far as what her out-of-pocket costs are. The only reason why I said regarding her husband is I do know he was in the military, so I didn't know if there was some sort of benefit there where it was at a reduced cost.
All right, well, in any event, I think what she said today is she's been covering health, dental, and vision since well before this calculation was performed. If that's true, she should get credit for it.
Oh, I agree. You can get credit
And
for it.
Mr. Van Dam shouldn't get credit. So I'm looking at what the wages were based on, and this was supposed to be effective sometime in 2019. Ma'am, it shows you at a monthly gross of just under $4,000.
Yeah.
And what you just told me is that's not what you made in 2019. Is that right?
2019, I was a total with my two jobs, 35,588. That was my adjusted
So clearly,
gross income.
And I know what the effective date of this is. Do we know when they performed the calculation, Mr. Anova?
It looks like it was run by friend of the court on April 30th, 2019.
So I'm assuming it was probably run at that time either based on year-to-date pay stubs or 2018 W-2s. Do either of you remember?
2018. If it's been since then, that's when I turned mine into, that's when I had Navarre. So
But
that's,
in 2018, do you remember, did you earn approximately $48,000 that year?
I can look real quick. I'm honestly, like, I have no idea. Hold on, let me look real quick, okay? I'm just getting my stuff together. 2018. 2018, I did adjusted income, $44,820.
All right, well, that number matches, but you're saying in 2019, you only earned 35,000.
Yes.
So, Ms. Terranova, the one advantage we have in the significant time lag that's occurred since this calculation was done and it's being addressed, we do have the ability to effectively use an effective date based upon when they did the calculation, but adjust the numbers based on what the parties actually earned, rather than what they were projected to earn. It would seem to me what we need to do is get that correct information. We can look at actual 2019 W-2s to figure out what 2019 earnings were. We can look at 2020 year-to-date and figure out what should happen for the current year. And we can get actual figures as to what mom's been paying for medical coverage. And if indeed dad's not been paying for medical coverage, that adjustment gets taken away. Let's get real figures and let's rerun the numbers. And doesn't that make sense?
I'm fine, Your Honor, because I am absolutely fine with that, because I think it should be corrected, because my client paying $1,000 a month is just way too high. So I am fine with doing actual figures. My concern about, if I understand correctly, Your Honor, is that Ms. Rogers doesn't only get W-2 income, Your Honor. I think part of her income is various businesses like essential oils and all these other things that she does.
And I get a 1040 for that. And I turned that in.
Hold on, Ms. Rogers, let her finish before you, I'll give you a chance.
Okay.
I'll finish your.
Thank you. And so I'm very familiar, litigating self-employed income. So it's not, I don't even know what to put it at unless I were able to see something. So it would be more than a W-2. I'd have to see what sales were and things like that, Your Honor.
Certainly. So Ms. Rogers, you have this
Oil.
Business that you operate.
And it's
You keep
I get a
records?
straight paycheck. And what I do is pay taxes out of that paycheck. And I can get the pay stubs and everything else. I am commission only. That is it. I'm only commission. I don't get a base pay. I don't get anything. So I mean,
got you.
yeah. So what my checks are is what my checks are. And then I pay my taxes out of my actual check.
But you've got those actual records.
Oh yeah, I can just print them off online.
Absolutely. I think we need both parties to submit to the friend of the court their actual earnings for 2019 and their year-to-date earnings for 2020. And have the friend of the court do a recalculation. We can still use the effective date of 2/8/19, but base it upon actual earnings for the year 2019 as opposed to 2018 earnings, which it sounds like aren't accurate for either party. It'll include the commission income from the oils business. In fact, any taxable income that either one of the parties is making should be included. Proof submitted of what's being paid for medical insurance, health, dental and vision, and let's do a recalculation. And then either party has the ability to object to that recalculation if we see that the friend of the court has done something incorrect. I mean, doesn't that make sense for everybody?
That's fine with me.
It does to me, Your Honor. Other than the fact of the, again, like I've stated, even if you threw in health insurance, my client, I mean, if it's gonna go retroactive, I guess if he keeps continuing to pay the $1,000 a month, if she understands that if it comes out lower, that would be money owed back to my client. Unless there
The
can be an
effect,
agreement that,
the effective date will remain the effective date.
thank you.
So you're telling me I'm gonna have to pay him back?
I don't know. It depends on what the calculation is.
Okay, well, if that's it, then Your Honor, I would also like to request that my ex-husband start paying the health insurance because that is from my husband who didn't have to cover these kids. This
Well,
whole
if,
thing, I know, can I finish really quick?
sure.
Because that is not my ex-husband's responsibility. And if they want to just lower the child support, that's fine, but he's going to have to cover that health insurance. I mean, it is what it is. He does not have to do that. He has no role, you know, as far as like society says, he has no
Miss-
role in my kids' lives. And this
Does
was a
Mr.
bonus,
Van-
you know?
Does Mr. Van Dam have health insurance coverage available through his employer at a reasonable rate?
I would have to double check the reasonable rate if it goes over the 6%, Your Honor. I'm not sure. I know he's previously done it. My only concern is whether they will allow if it's not open enrollment. I think there would have to be some order that orders him to place them back on, Your Honor, which if that's fine, again, I don't mean this negatively towards Ms. Rogers. I have agreed that if there's out-of-pocket expense, the guidelines say that has to go into the calculation. So, and it would seem to me if her husband is insuring herself and their other minor children, and it is not much of a cost to insure add their 3 children that she has with Mr. Van Dam, because I know she has another child with her husband. I mean, that seems, I guess, not cost effective. If it's not a huge increase. And I think that would have to be presented as to what the difference is to ensure Ms. Rogers, their child that they have together. Because it's my understanding it was requested by my client to have her insure the children. The insurance falls where it falls, Your Honor. I mean, if they don't want to cover it and it costs my client more, that's just more that would be taken off his
Your
tax.
Honor, those are not my ex-husband's children, and I'm not trying to be mean, but Terranova is Terranova right now.
Hold
is
on,
condescending, and I'm not.
hold on, please. So what I understood Ms. Rogers to say much earlier today is that when Mr. Van Dam was required to carry the insurance, he wasn't carrying it. She went in to get some kind of medical procedure done and found out they didn't have any insurance coverage. So she had to pick it up just so that they would be covered.
I had to go.
Ultimately,
I'm sorry.
I don't have a problem ordering Mr. Van Dam to cover it, but obviously at the point that he starts covering it, he's going to get credit for that in the child support calculation, and you're going to lose the credit on your side. I don't know where that ultimately shakes out, but I agree that Ms. Rogers' husband is not obligated to carry medical coverage for her. It's good that he's doing it for her children. It's good that he's doing that, but he's not obligated to, and that isn't coverage that's reasonably available to Ms. Rogers. That's simply what she took advantage of because they needed some coverage.
I understand, Your Honor, and my client is disputing that he ever took the children off medical insurance.
He dropped insurance. He dropped the insurance. Ask him why he didn't have insurance. No, let him talk. Why didn't he have insurance?
Your Honor.
At this point, it's not something I'm going to fix retroactively. She's going to get credit for what she's been covering, but
Right.
moving forward, if indeed Mr. Van Dam has coverage reasonably available through his employer, he needs to pick up that coverage. He needs to notify Ms. Rogers when that coverage is in place so that she knows when she can drop the children from their coverage. That pretty straightforward, I think.
And Your Honor, I have another question too. Oh, sorry.
Just a second. And the point at which he initiates coverage, there will need to be an adjustment to the child support calculation to delete the credit to Ms. Rogers and to add a credit in for Mr. Van Dam. So it looks like we're probably going to end up with potentially 3 different child support orders with different effective dates based on these circumstances.
Okay.
That's something the friend of the court is easily able to do. Sounds like that's what should happen. Ms. Rogers, you had another question?
Yeah, I would also like to add in, a lot of this too is due to, I take these kids to every single doctor's appointment, dental appointment. He took them to one appointment at U of M where my daughter still has metal in her mouth. He didn't tell me about another appointment needed to be scheduled. And there was a $750 part that was his to pay. And mind you, all of it's in my name, so it all goes against me. And I told him he needed to pay that. He left without paying that. I had to pay that up front that month, and I couldn't even afford to pay my rent. This is the kind of stuff though, like this is the reason why I wanted it to go to front of the court, so it was automatically taken out. But I am in charge of all these medical bills, and I take him to every single doctor's appointment. I have to take time off work. It's my schedule. He has to do nothing but pick those kids up for school and take them to school. His mom picks him up after school. I have volunteered at the private school where he was told that he needed to pay all the tuition to help out because we couldn't afford, he said he couldn't afford it. I volunteered. I did popcorn day for 4 years. I did parking lot duty up until I got pregnant, and I made him do that. And every single morning, 5 days a week. And I also did market day. All of this to keep his coverage down. And I volunteered for everything that I could possibly volunteer at St. John's schools for to keep the cost down so we could keep those kids in the school. And then for the past 3 years, we've had him somewhere else because he can't afford private school. He's pulled them out. The last time they were going to Marshall, he had, a motion filed overnight ex parte to pull my kids out of Marshall school to send them back to St. John's, all because he couldn't afford St. John's, and we agreed to it. He paid for football. He took them to football practice. And the first day of school, I had an officer show up at my house with an order for them to go back to St. John's school, the school that he can't afford. This is like what it's been going through. And he wouldn't let me have those kids. I've had cops at my house constantly when I lived over in Concord.
So Ms.
This is like
Rogers,
I've been trying to save him money. You know, this has been.
I appreciate your frustrations. I can't deal with those things today. I can tell you that if you have to pay out-of-pocket healthcare expenses, you are entitled to reimbursement from Mr. Van Dam for his share of those expenses. The friend of the court processes those sorts of things all the time. All you have to do is submit proof that you paid the expense, and they will saddle him with his share. The current proposed order that is going to get changed pegs you being responsible for 44%, he being responsible for 56% of medical expenses that are uninsured or not covered by insurance, deductibles, out-of-pockets, co-pays, whatever those are.
I'm at 44.
Well, you are under this current proposed order, but when we do the revised ones, those percentages will probably adjust somewhat. We won't know until they do it, but.
Because we just were 50-50 on the last bill.
Well.
Which is fine, I'm not complaining, but I mean, that's.
But the ones that he hasn't reimbursed you for,
We're
will
paid
be
up.
according to this formula. So what you would do, what we're gonna end up with is probably 3 different orders, which will have 3 different effective dates. So if you have unreimbursed medical expenses
Paid up, okay.
during the period from February 19 until whatever the effective date of the next one is, whatever the child support calculation says is his share, and if he hasn't yet reimbursed you for those, then you can get reimbursement simply by submitting a claim to the front of the court. They handle those things all the time. And it may take a while for this to get sorted out. It's a shame we're just now getting to the point of getting this squared away, but I'm hoping we can. It looks like this is the best path forward. Ms. Terranova, are you able to prepare an order that reflects all that I've directed here today?
Yes, Your Honor, I can draft that order. That was going to be my question. I can draft that order concerning all the issues of child support. Yeah, I don't have a problem doing that. I do need to address the other issues that Ms. Rogers in her other pending motion, Your Honor, when you're ready to hear me on that.
And the other pending motion, remind me, is what?
That was my question, Your Honor. She made statements about, I don't know if I guess I need to know if she's still wanting a change in custody. That
It sounds to me like what she would like is a change to reflect what the parties are actually doing now.
Actually, Your
She
Honor,
would like, she would like that to continue. That's what I understood. If there's more to that, you can elaborate.
I filed that motion. I believe that was after he had filed it. And then I tried to do another one through Gary because my ex-husband, something happened at my house where I went to early labor. A girl that he was talking to came over to try to fight me at my house when I went into labor and almost lost my baby, who was one of my best friends. So at that point, I felt like he was endangering it when he was with a married woman and involved my children, and they got caught, and it caused a huge thing, and she came to my house. So yes, I was trying to change custody on it because of his actions and the lifestyle he lives. I really feel was not appropriate for my children to be in. And I had went through that with Gary, and I don't know if Gary filed it or anything else.
well, I mean, I guess maybe I'm wrong, but if the parties are currently exercising right now what they want to be exercising, then I don't think there's an issue because they share joint physical custody.
But I have the kids, like whenever he's at work, I have those kids. So I am feeding them breakfast, lunch, and dinner when they come over. They come over to my house at 8:00 in the morning. He took in the original agreement, that was what I understood, was I was to have those kids until 3:45 till his mom got out of work. She would always meet me when I worked at Grand River. She would meet me at Grand River, get the kids, and then take them home till 7:00. That was I want that back. And he took that away from me when that was what it was.
Your Honor,
And then over this COVID, he gave them back to me. That was what had happened.
And you'd like that to continue?
Yeah, I want my kids to be safe. They need to be on a structure. We have 2 kids with my son. Hold on real quick though. My son has a severe learning disability.
I think that's what I said, Ms. Rogers, that what you would like to do is have the order reflect what you and Mr. Van Dam are currently observing.
Mm-hmm. Well, he's not doing that right now. On his days, his mom is taking them.
Oh, then
Right
I
now,
misunderstood you completely.
Right.
You're saying there was a period of time when he was doing that, and now he's not doing it again.
Yep. So for the first 2 years, yeah, I had them. Then I got with my husband, and when we started seeing each other, they were taken away, and actually we were keeping them up until, 2018 when we moved out to Concord, and I had them until, because Layla was slipping in work. I have all her report cards, and I said it's just better if we get a structure down because they weren't doing homework with his mom. So, and it worked out great. Her grades were up. She was getting all B's, you know, a few A's, and it was working. And then I moved out to Concord.
So the modification you would like is that the current custody, joint custody arrangement continue, but that when he has to engage a babysitter, you want the right to watch the children instead of having the babysitter watch them.
The grandma, yes. Because I thought that was in our first agreement, that I had also had first right of refusal, which I don't.
Well, I can look back at the judgment of divorce and see if that's what that says.
It
Your
doesn't.
Honor, it is not contained in the judgment of divorce.
And I just said that it's not.
All right. So you're saying at some time in the past you observed that, but when you entered into the judgment of divorce, that
It was not put in there.
disappeared. And you'd like to have the right of first refusal back.
Well, I would like to have it. It was never in there. But we talked about it in court. Eric did, and it was not put in there.
I gotcha.
If I
Whether
could
it's back or not, you'd like a right of first refusal. All
I would
right.
like to have my
Ms.
kids. I
Terranova?
mean,
Your Honor, at this point, we have the child support stuff moving, which is good. So we can leave that puzzle there, get everything to front of the court, hopefully get that resolved. What I'm hearing is the issues that she originally had back when she filed a motion with Mr. Schutte have been taken care of with, I don't know, she said she filed some, I would either ask that she be required to file a new motion to figure out where we are with anything so that we know what's going on, because some of this stuff is so old. I don't even know what we're referring to. My client has huge issues with the treatment of Ms. Rogers' current husband when it comes to parenting time exchanges. So I know Ms. Rogers has been able to speak for lengthy time on that issue. So what I would suggest to this honorable court is have Ms. Van Dam or Ms. Rogers file a new motion as to what exactly she's asking for with current situations. We can't go back and talk about what happened 5 years ago. And then we can address that on a motion morning, and this court can figure out if there's been a change in circumstance or proper cause to have it go forward to an evidentiary hearing.
All right, well, I'm just looking through this to see what, if any, motions of Ms. Rogers are pending.
no, Gary and I parted ways. I can't afford a lawyer anymore.
Right,
Well,
so that's
you
why I was
certainly
suggesting anything new can be done by a new motion.
Yeah, for sure, I'll file a new motion.
I think that's appropriate because I'm not seeing a pending motion in the file.
Yeah, no,
Okay,
So let's do that. Let's get the child support issue resolved as I've already ordered. And then as soon as Ms. Rogers files a new motion, we'll get that noticed up for hearing. And I'll address it at that time. And put in your motion exactly what it is you're seeking.
okay.
So that
and how
Ms.
do I
Terranova
file
has
a
something to
motion?
respond to.
Do I just go to, because
Just file it with the clerk's office. I think you gotta make an appointment.
okay,
Call them, tell them you have something you want to file, and then they will tell you when to bring it down, and they will receive it from you at the time that you file it.
okay. And so, for each, like, what I would like to go through, it's like, say if I still wanted the guardian ad litem, I would have to file a different motion for that?
You can include it. You can include everything in one motion.
Oh, okay,
Okay, let's do that. And then as soon as we see that, we'll get it noticed for hearing, and we'll deal with that as a separate issue.
okay.
Okay, very good. Ms. Terranova, I'll watch for that order. Ms. Rogers, I'll watch for your motion.
Thank you.
thank you, Your
You're
Honor.
welcome. Have a good day.
You too.
Thank you.